Looks like people are ready to go. Am I correct? Okay. We're here today in the matter of Nationwide versus Polk County Board of Review. And Nationwide is represented by Mr. Moore. And Polk County is represented by, I believe Mark Taylor will be arguing. Is that correct? Yes, Your Honor. Thank you. You may begin, Mr. Taylor.
Thank you, Your Honor. May it please the court. The significance of the Nationwide decision, in this case in a property tax assessment appeal, is as follows. But for the presence of the minimum assessment agreement for 1100 and 1200 Locust Street, the Iowa Court of Appeals decision in this case would have resulted in a reduction of $38 million in assessed value for 1100 Locust Street and a reduction of $18,910 for 1200 Locust Street. The only evidence of market value would have been the testimony and reports of Nationwide's experts, since the appraisals of the Polk County Attorney's Office and the testimony were found incompetent based on an extreme interpretation of Iowa Code Section 441.21 and in conflict with Iowa case law dating back to 1979 in the equitable life insurance case versus the City of Des Moines. The Court of Appeals decided the Board of Review experts were not competent because they did not follow Iowa's statutory scheme for property valuation, because neither expert relied upon the sales comparison approach. Now, Your Honor, no one is denying that the sales comparison approach is the preferred method of establishing market value under 441.21. But if the court would look at what happened in this case, all four experts, including Nationwide's experts and the Board of Review experts, utilized all three approaches to value: the sales comparison approach, the income approach, and cost approach. And not a single expert in this case relied upon the sales comparison approach. Their experts testified that they gave more weight to the sales comparison approach. One expert, Scaletti, says, I gave 60% to the sales comparison approach and less weight to the income and cost approach. Their other expert, Don Vasky, testified that he gave more weight to the sales comparison approach and less weight to the other approaches. Our experts testified, Mr. Monarch, that he gave equal weight to the cost approach, or excuse me, the sales comparison approach and the income approach. And our out-of-town appraiser, Mr. Kenny, testified that he gave most of the weight to the cost approach and less weight to the sales and income approach. And if the justices will look at page 9 and 10 of the Board of Review application for further review, we have listed all three approaches that the appraisers use and the reconciliation value. And if one were to assume that these appraisers were completely relying on the sales comparison approach, then you would expect those sales comparison approach numbers to be the same as the reconciliation numbers. But that's not what happened in this case.
Let me, interrupt here. So let me try and distill what I think you're saying. What you're saying is that regardless of what the Court of Appeals intended to do on its de novo review, it should have taken all of four of the experts into account. You don't exclude two of them as incompetent, where they actually did the method that the Court of Appeals said was the preferred one. And you just consider all four of the opinions, and then you come up with an evaluation. Is that your view?
To get to the heart of the arguments, to look at the cases beyond the numbers, look at the properties, and look how they did adjustments. So which are the appraisers are more credible and persuasive, instead of excluding the testimony of our appraisers. That's an extreme example, Your Honor. There's only two cases that I could find. Is the Campiano case from this court, where the experts were excluded. And in that case, they didn't do a sales comparison approach. They only did an income and a cost, but relied solely on the income approach. So they violated the statutory scheme by not doing a sales comparison approach, and they relied on one factor. Instead of, they could have gotten by with a cost and an income, but they only relied on one of those factors. The thing that distinguishes that case, Your Honor, is that there were sales out there, and their experts knew about them and chose not to use them because they thought commercial buyers of this type of property don't look at the sales comparison approach. They want to know what income this property is going to make. So
the Court of Appeals ruling, it seems to me that they sort of find that Nationwide's experts relied on sales more than your experts. Why are they wrong about that?
if you would look at the Heritage Cablevision case, which is cited in our table of authorities, it specifically addresses that issue, Your Honor. It talks about, this is cited in the district court, that they cite the well-marked decision about finding the fair market value through comparable sales as the preferred method, but then they also talk about the other factors approach. And it says, other factors may be considered if and only if market value cannot be readily established through the sales comparison approach. But the well-marked decision never describes what readily established means. If one looks at this court's decision in Heritage Cablevision, it says the statutory preference for evaluations based upon comparable sales applies only to those situations where the value may be readily established by that method alone. In instances where the value cannot be established solely by comparable sales, there is nothing in the statute which requires comparable sales data to be weighted more heavily in the other factors approach than other relevant data. So if one can solely rely on the sales comparison approach and there's adequate sales, then market value, the sales comparison approach has to be used. The income approach and the cost approach don't become competent evidence in a tax assessment case. But if the parties cannot solely rely on the sales comparison approach, they do all three approaches and give various weights to those approaches, it doesn't matter how much weight you give the sales comparison approach versus the income approach. According to the Heritage Cablevision, they look at all three approaches, and therefore, when the Court of Appeals decided, because Nationwide's appraisers gave more emphasis or more weight to the sales comparison approach, they win and we lose, that's in direct contradiction to what the Heritage Cablevision case says. And the Heritage Cablevision case came after the equitable case where it talks about using all three approaches to value and how it's implicit that the sales approach cannot be relied upon solely to decide market value.
When was the statute last updated?
1967.
Here's another question, and maybe this is a question he'd ask Mr. Moore as well, but you know, we don't take many of these cases. You know, we're not in these property tax valuations. We took one just a few years ago with regard to a building that one might argue is somewhat similar in that it's a really large building in downtown Des Moines that was kind of tailor-built to be a headquarters for a company. And in that case, we said, well, you can't really look at comparable sales. That isn't really the appropriate method. And we used a different approach to come up with it. And the Court of Appeals kind of, you know, went in a different route. It didn't follow the approach that we took in the Wellmark decision. Why isn't Wellmark relevant and maybe even controlling here?
Wellmark is controlling in this case, and all the way through the hearing, we argued Wellmark, that this Nationwide building is actually larger than the Wellmark building. It's almost 800,000 square feet, and the Wellmark property was 600,000 square feet. So basically, we argued all along that the sales approach wasn't, in Wellmark, they had the same situation, is nobody could find comparable sales locally that matched up with the Wellmark building.
I'm reading these appraisals, and your appraisers say that you know, rely on comparable sales from California, which I suppose I would if I was, you know, attempting to support a large value. And Nationwide's appraisers rely on comparable sales from Little Rock, Arkansas, and I suppose that's what I would do. But one can argue that both of those are limited values. Certainly, you know, for a trier of fact, how do they know how to adjust Little Rock to downtown Des Moines or somewhere in California to downtown Des Moines? So why doesn't, you know, Wellmark just control here?
Wellmark should control, and that's why our recommendation to the district court was that the cost approach should be used in this case, because when we looked at the comparable sales, not only ours, but Nationwide, through the prism of the Wellmark case, there was multi-tenant properties being used. Wellmark says don't use multi-tenant properties. And there was corporate headquarters being used from California, Texas, and all these, because that's where our appraiser, Mr. Kinney, could find single-tenant corporate headquarters of the same quality and size of our buildings here. So we argued that all the way through that the Wellmark case controlled this, the nationwide case, and I do believe, even though it wasn't articulated very well in the district court opinion, that Judge Scott was relying on the Wellmark case because he did value the nationwide 1,100, 1,200 locusts under the cost approach, excuse me. So, Judge, I think you're correct. You're exactly correct. Is the Wellmark decision controls this, and the Wellmark decision talks about the other factors approach, which I just discussed earlier. That if you can't solely rely on the sales comparison approach, if you look at the building, and it isn't comparable or isn't as close, the other factors approach comes in, and you end up having a cost approach and an income approach. And I believe the cost approach, the district court was correct in using the cost approach to value 1,100 and 1,200 Locust Street. The best sale, Judge, would be another corporate headquarters building in the Western Gateway section of downtown Des Moines. But nobody had one of those. They used sales that were large. I forgot the 909 Locust Street, the Federal Home Loan Bank, and I believe it was, there was another 400 square foot building that was used as sales comp number 1, but it's a multi-tenant building. The best they could find, Judge, were multi-tenant buildings. Nationwide came forward with 100,000 square foot buildings and said, these office properties are comparable. They're not corporate headquarters buildings. They're not 800,000 square feet. They're not built with atriums and cafeterias and all these other things that you would never put in a multi-tenant building because you're going to want to lease or rent out every square inch of that property.
There is a distinction between the nationwide buildings and Wellmark, isn't there? That the Wellmark building had just been built, and there was a cost figure for this brand new building. That's not the case here, is it?
This, I believe the nationwide or the Wellmark building was barely over a year old when the appeal came in. This building here, Judge, would be a little over, I believe it was 12 to 13 years old when this appeal came up. But we know in 2015, when this property was assessed, if the assessed value, Judge, was $80,230,000, and 1,200 Locust Street was assessed at $41,390,000. And between 2015 and the 2017 assessment, Nationwide put in $13 million of remodel. So they're continually remodeling these buildings. And what the Nationwide individuals are doing in their case is they're basically asking for half the reduction. They're asking for $50 million on a building that's continually being updated. They're spending millions of dollars. And the judge asked them, Judge Scott says, well, if I own my home for 10 years and I'm doing upkeep, wouldn't I expect to get something out of it? Why would these sophisticated corporate headquarters owners put all this money into a building if they're never going to get that out? Why would they?
Interrupt you because you're almost out of time here. Can you address the issue of the value that was placed by the company for their insurance purposes?
Looks like, Judge, for insurance purposes, it was $148,061,365 for 1,100 Locust, and $67,804,793 for 1,200 Locust Street. And that was those exhibits were offered as evidence in the case, which I believe under the Ruan case, one can look at under the other factors approach, insurance and other forms under the cost approach to sustain the assessment.
What's your argument on that?
Judge, I believe, and that's why I was making that argument, and I put that into my brief that should be used because a couple of my appraisers, especially on the 1200 Locust Street, were coming under the value under the cost approach. So I made the argument that the insurance showed that it was worth more than what it was being assessed for. And even if one were to depreciate that $148 million insurance value, it would still be above the $87 million assessed value that we currently have 1100 Locust Street on. The whole thing, Judge, is the other side was asking for extreme reductions on a building that has been upkept, the upkeep, millions of dollars in investment, appraisal showing that our appraisal showing that it was worth, well, in the cost approach, well over the assessed value, that they were asking for valuations that were half of what, way below the minimum assessment agreement and way below what we had it assessed for, and therefore were not reasonable. And that's why we thought it was a travesty that the Court of Appeals in their de novo review didn't look at the sales, didn't look at who was more credible and persuasive, what adjustments were made, because there's several properties where their appraisers used the same properties we did.
We'll get a chance to talk again in a little bit.
I want to thank the court for giving us this opportunity to present our case.
You'll get to come back. You'll get to come back. Thank you. And now we'll have Mr. Moore.
Thank you, Your Honor. May it please the court, counsel. As you can imagine, Nationwide has a different view of this case than the board. But we do have one view that's kind of similar. I do believe that the Wellmark case is the case to look at. And as far as I'm concerned, Nationwide followed that case to the letter in trying to find, do an appraisal that met the standards of Nationwide and that we could go forward and present that evidence to the court. In Nationwide, in Wellmark, there was the underlying case, there was a bench trial that lowered the value from $99 million to $78 million. And the district court found in that case that the value could not be readily established by comparable sales approach, so they considered other things. And they lowered it from $99 million to $78 million. And then the Court of Appeals agreed and affirmed, and then the Supreme Court overruled that and knocked it back up to $99 million. But in their decision, they did set out, what the standard was and what you have to do to find out how you value these buildings. And so what happens, this case is about how to value these two large single-tenant buildings. And the fighting issue in this case, fighting issues are, number one, when can the court ignore comparable sales and rely on other factors to determine the fair market value of a property? Number two, who has the burden of persuading the fact finder that fair market value cannot be readily established through comparable sales, so the court can consider other factors? And third, has the board met that burden? In this case, on de novo review, the Court of Appeals found that the board had the burden of persuading the fact finder that the fair market value of these two properties could not be established by comparable sales. Yes?
The credibility call that the district court made here in favor of the board's experts.
I'm sorry, I didn't hear the question.
What are we to make of the district court's finding on credibility as to the board's experts versus Nationwide's experts?
The district court did find the board's experts more credible, but however, he did not show the basis of that and did not make any finding on the reasonableness of using just comparable sales on finding the value of the property. Also, the district court made no finding regarding whether or not the board, Nationwide's experts were presented competent evidence. And in fact, they found that we did meet our burden under the code, that we did present competent evidence, and then it shifted. So then you get to the board, the district court then has to weigh which they like, which set of appraisals that they felt more comfortable with. On de novo review, the Court of Appeals found otherwise.
Court of Appeals, or one problem potentially, is the Court of Appeals just excluded the county's experts, at least from what they said. They said they were incompetent.
I think that's an overstatement, Your Honor. What they said was they didn't present competent evidence of comparable sales. And I think it's undisputed. In fact, they admit as much, the board does, that they did not present competent evidence of comparable sales. In fact, they
Present competent evidence of the value. Competent evidence, not we think the evidence is more persuasive on one side or the other. They basically threw that out. They didn't necessarily, they said, well, we don't really know what the value is, but it's going to be less than these agreed upon minimums, so we'll just establish the minimums. And that seems to me, it's a little bit of a shorthand. I think, don't we have to do a little bit more if we're doing the de novo review? Don't we?
The problems we have with this case is I do believe that in other cases I've done like this, and I think in the underlying case in Wellmark, the original decision, there was a bit more of a developed decision from the district court that you could look at. But on de novo review, I believe there's enough evidence that we presented in this appeal, and there's evidence that the Court of Appeals looked at as well. For example, on page 5 of their opinion, they cite to our expert, Don Vasky, and his testimony. And he states, there are sales of larger corporate home offices. I analyzed 2 in Des Moines. You go to Midwestern communities, Kansas City, Minneapolis. There are examples of sales. And
in the Wellmark case too, and the conclusion that we reached there was, you look at a building of that magnitude, it's kind of a unique situation, and comparable sales don't really cut it. I mean, they are. How do you know if they're comparable?
I don't agree with you about what happened in Wellmark, because in Wellmark, they did not have comparable single-tenant large building sales. In Wellmark, Mr. Vasky, his company, was part of that for the taxpayer as well. And what the taxpayer did in Wellmark is they did multi-tenant Des Moines area properties, okay? That's what their comparable sales was.
Correct it, because it's been a few years, and you know it better than I do.
They did these huge corporate headquarters in Tampa, San Francisco, Dallas, that had really no relationship. And so what this court said in Wellmark then was like, well, listen, we can't use these huge corporate headquarters in other states and the coast where the market's nowhere near.
If the comparable sales that your experts used were enough and they needn't look no farther, then why did your experts use the other 2 approaches? Hey, we have the sales, we need not put anything else in, we're done.
Testified to that, Your Honor. What they do is, and this is typical, I think every appraisal I've seen, unless there's something very strange, they do the comparable sales analysis, and then the other 2 analyses are checks. They'll use them as checks on, okay, if I do the other ones, is that going to confirm my comparable sales analysis, or is it going to be completely different? And so it is not unusual. In fact, I have yet to see an appraisal in a commercial appraisal where they didn't use all 3.
Let me get back to you on the Court of Appeals. Here's a direct quote from the decision talking about the board's experts. Neither expert relied upon the sales approach to value the property. That's not true, is it? I mean,
Your Honor.
The Court of Appeals decision. I'm reading, on our de novo review, we find the board's experts, Kenny and Mandernack, did not present competent evidence of the value of 1,100 Locust and 1,200 Locust. Neither expert relied upon the sales approach to value the property. Now, that's not really correct. I mean, you could, all of the experts went through all 3 approaches. So they did rely on the sales approach to determine one of their valuations of the property. They said the board's experts, one of them said the the sales approach was inferior. The other one said it was of equal weight to one of the other approaches. But everybody did a sales approach. So why is it that the board's experts just get removed from the case in the Court of Appeals view? I don't understand.
Because the board experts did the two methods that the Walmart court specifically said you can't do to do a sales approach for a building like this. The Walmart court said you don't do multi-tenant because that's too far away and you can't make a number of adjustments. And you don't do ones from out of state in large areas. Well, that's exactly what the boards did. Mr. Mandernack did multi-tenant, which Walmart said you can't do multi-tenant to value these buildings. And then Mr. Kenny used these huge, corporate headquarters buildings in much different markets. And in Walmart, the court said, well, you can't use those either. And so that's why the Court of Appeals said, we can't give any weight to their sales approach. And on top of that,
I don't think that's in the Court of Appeals decision, is it?
well, they don't say that in the Court of Appeals decision, but in our briefs we say it, and the board doesn't deny it. I mean, the board, that's what they did. And on a de novo review of all the facts and applying Wellmark, I think it's clear that the board just missed the boat on how to do a sales analysis. Now, what they could have done is when our two appraisers, Mr. Scaletti and Mr. Vasky, when they testified, I suppose they could have said, well, we're questioning this. How can you use this type of property as a comparable sale? And they did question some of the adjustments, but the adjustments are always part of the factors. But they never, ever presented a sales analysis that would meet Wellmark. They didn't even try. And frankly, I couldn't understand why.
Now here, I did participate in the Wellmark case, and I don't read it as saying, is laying down absolute rules. I think in Wellmark, we were the de novo fact finder of last resort, and we found as a fact that the different comparables that had been offered by both sides were not really helpful in the end. They were just too different from the subject property, and it was too unique a property. And therefore, we decided to apply the cost method. Isn't that, essentially what we did? And why couldn't we do that in this case? If we came to that conclusion, we might not.
And that actually, when you look at the code, it says comparable sales is what you want to use. If you can't get within the ballpark of using comparable sales, you use other factors. And in Wellmark, the district court said, we're just going to have to use other factors. They said it right from the beginning. Then the fight was just over the number. The Court of Appeals agreed with the number that I think was Judge McClellan came up with. And then the Supreme Court decided, no, we know we're going to use other factors because we don't disagree with what the two lower courts have said, but we think the number should be higher. But what all three courts agreed on was that the two methods used by both sides, by Wellmark using multi-tenant properties, they said that ain't going to work. That is not something you can use for comparable sales. And the board using, Tampa, New York, San Francisco, that's not going to work. And that's exactly what they did here. And I understand that in the law, there's no real bright lines. There's a few bright lines, but not a lot of bright lines. But when the decision in Wellmark says you can't use multi-tenant and you can't use these large out-of-state ones, and that's exactly what they use, in my opinion, they have definitely violated Wellmark. And so,
any should we give to the insurance values for the building that Nationwide placed on them?
none. When you look at the statute on valuation, there's nothing about insurance valuation. And those insurance valuation, Your Honor, is of course replacement costs. And so, it's comparable, I guess, to, the cost basis. Well, when you do a cost basis analysis, and I had a lot of criticisms of the cost basis analysis that was done by the board, but when you do a cost basis analysis, you still take off real depreciation and then obsolescence, which is just another form of depreciation. And so it would never be that number. And so that's using one of a technique that is recognized by the Institute for an appraiser to value something. There is no technique recognized that one way to value real property in the state of Iowa or anywhere that I know of is based on its insurance valuation. Just want to hit a few more points. First of all, one of the points made by the board that I do take issue with is the claim that, well, and it was in their application and it was raised a little bit here, this will result in huge consequences throughout the state for taxing entities. I don't think that's true at all. There is nothing stopping a taxing agency from performing an appraisal and having an appraisal and finding other large single-tenant buildings that sold and using those for comparable sales. And you have to do adjustments, I understand that. But people do it all the time. Don Vasky said in his testimony, this is an insurance town. This is a business town. There are large buildings that are single-tenant that come up for sale. So, this isn't something that never happens. It happens. And we went out and did it. Now, Mr. Vasky, one thing that he had going for him in this deal, as I told you, he was representing Wellmark. His company was one of the appraisers. So he was very aware of what Wellmark said about the appraisals that they did before. And so he was going to be sure that we're going to get the kind of comparable sales that the courts are going to like. So just to finish up here, so for 2017, 1,100 and 1,200 locusts were valued at $87 million and $44,900,000 respectively. Applying the minimum assessment agreement, the Court of Appeals reduced those valuations to $78,500,000 and $36 million. And just this week, the City Council of Des Moines agreed to purchase 1,200 locusts from Nationwide for $30 million.
In our record, can we consider that even?
I would object that it's not relevant. It happened this year.
Well, I would just note that to give you an idea of when these do sell, they sell. And so all the competent evidence produced at trial supports evaluation at the minimum assessments, and the Court of Appeals decision should be affirmed. Thank you. Apologize for going over.
Comment, now I feel like a trial judge. We will not consider any evidence that is not outside of the record, so you can be assured of that. There's no jury sitting here, so we will unring that bell. You may proceed.
May it please the court, unlike Nationwide, we're arguing to the court that all four appraisers are competent. We think that all the appraisals should come in and that the court should look at all the evidence and decide.
You there for a second. The way I read the Court of Appeals decision is that they said that it's on the board's, it was the board's burden to first say that comparable sales isn't appropriate, and then we can move and look at cost and they said that you didn't meet that burden, that your experts didn't provide proper comparable sales, and you didn't meet your burden, so that's why they excluded it at the very first. What is your response to that argument by your?
They're wrong that our appraisers did all three approaches to value. The thing is that they just didn't give all the more weight to the sales comparison approach.
Was saying as the threshold, first you need to say, the district court should have said, I find that comparable sales is not sufficient on its own. Did the district court need to say that, and did the district court say that inferentially, if not expressly?
I believe that the court didn't directly say that, but I think if you look at the Wellmark case and how the court resolved, they did come to the conclusion that the cost approach is the appropriate method. But did the district court actually say that he didn't find comparable sales and we could move to the other factors approach? No, the district court never said that. But we think it's clear, Your Honor, that the Heritage Cablevision case talks about if one is not solely relying on the sales comparison approach, that you're using all three approaches, that's another factors approach, and it doesn't matter how much weight one gives the sales comparison approach in comparison to the cost or income approach. Everything becomes relevant. And also, Your Honor, the Swayford case talks about that that the court should take all the evidence in, that it should not exclude based on competency. It should look at the evidence and decide which evidence is more persuasive, which evidence is more credible, and the Court of Appeals never did that.
What's your response to your opposing counsel's argument that the board's experts' comps were outside of what we said in Walmart were proper comps.
The thing that I would talk about that is, one has to remember that in the Wellmark decision, the court still found those properties that were presented by the Board of Reviews competent. They all came in, they just decided when they looked at the sales comparison approach, the income approach, that the cost approach was the most. They didn't exclude the sales comparison evidence. They found the cost approach evidence more credible. And the thing is, what Nationwide went out and got smaller buildings and said, these are comparable. Well, the thing is, they're not corporate headquarters buildings. Our appraisers actually tried to go out and find corporate headquarters buildings, and that's why Mr. Cnty went nationwide to find in San Francisco and Texas, to find 600,000, 800,000 square foot buildings. The Nationwide testifies that their appraiser, Mr. Vesey, said you drive around Des Moines, you see these buildings everywhere. Well, if they're everywhere and they sell, why aren't they using them? Why aren't they using a single tenant principle?
It does strike me that there's not a qualitative difference in the evidence that's presented. I mean, both experts talked about comparables that were in, to the extent they were headquarters or single tenant buildings, they were generally outside of Des Moines and other markets. Is that correct?
Just like in the Walmart case, where are these 700,000 square foot corporate headquarters buildings in Des Moines? That's why they looked at Arkansas and looked at Texas. I mean, we think that ours are just as comparable or incredible as.
Our experts said because of that, we give less weight to the comparable sales as opposed to Nationwide's experts.
Another thing, Your Honor, when you look at, I know that we're talking a lot about sales, but if you look at the cost approach in your de novo review, did you realize that Mr. Scaletti, the appraiser for Nationwide, valued the 1,100 locusts at $175,884,992. He finds there's 82.6% depreciation on this building because it's so large that no one's going to buy it. And these are the same arguments that were made in the Walmart case. We're saying that they're not valuing this as a single tenant. They're not looking at that hypothetical buyer that's going to come in and use this building at its current use as a single tenant, 700,000 square foot building. They're saying this is going to get chopped up. So by the time Mr. Scaletti takes away his 82.6%, he values 1100 Locust Street at $30 million. When he ends in his land value, he ends up at $39,000 or $39,470,000. But the thing that's shocking is his sales comparison approach values are even lower than that, Your Honor. And one of the sales that he uses is, and he does the same thing for 1,200 Locust, 75.5% depreciation, starts at 77 million, gets down to 23 million. And their other appraiser does the same thing. 1,100 Locust starts at 137 million, depreciates at 67%, values the building at 45 million, and then adds in his land value for 54. So when the court looks at these buildings and sees that all the money that's been put into these buildings and they're undercutting and they're basically saying they're worth half of what they're currently assessed for.
If you want to give a final comment, you sure can.
Your Honor, I would just say that I believe that in the de novo review that our appraisals are as competent as the Nationwide. Everybody used all three approaches, and just because our experts, because of the nature of the building, didn't give as much weight to the sales comparison approach, shouldn't exclude them. Our appraisals were competent. All the evidence should come in, and we believe that the Court of Appeals decision should be reversed and the district court decision affirmed. Thank you, Judge.
The case of Nationwide Mutual Insurance Company versus Polk County Board of Review is hereby submitted, and court is adjourned for this week. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.